for the late start here, but I believe we are ready to go. The Minnesota Senate Labor Committee is called to order. We do have quorum, and I think we may even have, oh no, we don't. Do we have all of our members here? Oh, look at that. All of our members are present. Lovely. Members, we have two bills on our agenda today. Senate File 2373 is our proposal for the Labor Committee Finance and Policy Bill. That is up first. And then second, we have Senate File 3720, which we will amend with the recommendations from the Workers' Compensation Advisory Council, which the Council passed on Monday. On Tuesday, we started conversation on our Omnibus bill with our council, Ms. Doyle-Fontaine and Ms. Bird, with their walkthrough of the amendment and spreadsheet. Today, if any questions have come to mind since our walkthrough on Tuesday, I would invite you to ask them. As we get started today, we'll begin with a brief presentation of our Omnibus bill and take testimony, and then we'll move on to committee member discussion. So with that, I am going to pass the gavel to our Vice Chair, Senator Hallström.
Welcome to your committee, Chair McEwen. We have Senate File 2373, and I believe there's an author's amendment to get it in the shape you'd like, the A18.
Yes, thank you, Mr. Chair.
Great. So Senator McEwen moves the A18. Those in favor say aye.
Aye.
Opposed, nay. The A18 amendment is adopted. Senator McEwen.
Thank you, Mr. Chair. Members, I am pleased to present Senate File 2373 as amended. This bill contains funding for important work that the Department of Labor and Industry does to protect meat and poultry processing workers. It would also restore the right to sit, a Minnesota law for 86 years from 1887 to 1973, which would provide a valuable common sense right to workers who are remarkably currently denied the ability to sit while their job duties would otherwise allow them to be seated, and which would also enfranchise others to apply for jobs when they may otherwise consider them outside of their abilities due to length of time workers can be expected to stand in certain roles. And this bill would also enact very basic protections for workers by regulating what employers may use AI or machine learning tools to do, including prohibiting employers from using automated decision systems to cause the worker to break the law, infer a worker's immigration, personal identity, or protected class status, violate the worker's legal rights, and it would prohibit employers from using electronic monitoring systems to discern those same things, as well as to use those tools to gather a worker's facial, gait, or emotion, to monitor workers outside of their work or in private settings like bathrooms, or to require that workers physically implant devices that collect or transmit worker data in their clothing or person. This bill also contains the minor league baseball provision from Senator Pappas that we heard about on Tuesday, a provision from Senator Mann that we heard last year to require transparency in employer cost sharing in healthcare plans so that workers know whether their chronic illness will preclude them from accepting a job offer before they go through that job application process. And the bill also contains several provisions from the Department of Labor and Industry, which will help streamline the licensure work that they do. With that, members, I ask for your support, and I look forward to hearing from our testifiers.
Thank you, Senator McEwen. We will now move to our testifiers. Up first, we have Michelle Mazer, and on deck, we have Lauren Schothorst. Welcome to the committee. If you could introduce yourself for the record and please proceed with your testimony.
Good afternoon, Chair McEwen and members. For the record, my name is Michelle Mazer, and I'm here to express AFSCME Council 5's support for several provisions in the Senate File 2373, the Omnibus Senate Labor Bill, and thank you for considering my testimony. I want to start off by thanking you for including our proposal to require employers to offer seating when it's reasonable. I also want to note our appreciation for amending this bill back to including stools again. And I won't repeat all of my testimony from earlier this session, but I do want to reiterate that this provision was Minnesota law for almost a century. It is a very simple and affordable remedy that makes a major difference for the provision of workers, their bodies, and ability to work in the state of Minnesota. While it may seem to only apply to a small percentage of workers, this legislation makes a big, important impact for workers whom it affects. This allows our constituents, your constituents at different life stages and abilities to contribute to the Minnesota economy for longer. Many workers across the state rightly take it for granted that they can sit down, just as we are right now, from time to time without needing to take a full break from working. This law is designed to protect that fraction of workers who are stuck in a position where the employer is being unreasonable. And for the thousands of employers that are reasonable on this issue, they won't see any difference in their day-to-day operations because of this provision. I also want to note that we support sections 5 through 8 of the bill, which regulate how employers can use AI products that surveil workers and can make decisions about their job performance. These technologies have made it much easier to scrutinize every aspect of what some of our members do, and they have the potential to collect information that goes well beyond the efficiency metrics. These AI products can learn or infer all kinds of personal information that have no relation to the work we do, and placing simple guardrails on what an employer can have AI collect from a very small, from them is a very small regulation that Minnesota's workers deserve. So thank you again, Madam Chair and members.
Thank you so much for your testimony. Up next, we have Lauren Schothorst, and on deck, we have Dalton Danielson. Welcome to the committee. If you could introduce yourself for the record, and please proceed with your testimony.
Good afternoon, Mr. Chair, members of the committee. My name is Lauren Schothorst. I'm the Director of Workplace Management and Workforce Development Policy for the Minnesota Chamber of Commerce, a statewide business organization representing more than 6,300 businesses and 500,000 employees across the state. A majority of our members are small to mid-sized businesses. The Chamber appreciates the opportunity to testify in opposition to Senate File 2373, the Labor, Finance, and Policy Omnibus Bill. Because this bill contains a number of provisions that we've already testified against during the course of this session, I'll keep my testimony short. Industries across Minnesota's diverse economy are experiencing several troubling trends, including high costs, steep increases in regulation, and business mandate on workplaces that are already heavily regulated in Minnesota. Instead of reducing costs or making it easier for Minnesota businesses to remain competitive, this bill takes the opposite approach. Specifically, in Article 2, Sections 2, 3, 8, and 9 add additional enforcement powers and penalties against employers for new liabilities imposed. Section 4 adds additional requirements to a newly imposed job postings mandate. Sections 5 to 7 seek to regulate AI and prohibit various automated systems and electronic tools in Minnesota. In your packets, you can see a letter from a coalition of nearly 30 statewide and national business organizations also opposed to these provisions, and Section 9 imposes a new seating requirement on employers. Throughout this session, we have shared our fundamental definitional questions and scenarios to highlight that language that is up for interpretation can lead to litigation risks and unnecessarily subject business to penalties. We've flagged a few areas where overly broad definitions or inconsistent definitions may inaccurately or unintentionally capture practices or tools in ways that could create serious challenges for businesses and negatively impact employees, customers, and citizens. Unfortunately, Senate File 2373 introduces a number of vague but consequential new requirements on employers of all sizes and industries. Minnesota employers, employees, and communities are counting on lawmakers to work toward an agenda for economic growth, making Minnesota's economy stronger, more vibrant, and more viable. Balance is necessary to protect public interest and promote economic growth. The Chamber would prefer to be working with members of this committee to pursue reasonable bipartisan solutions that strengthen the economy while keeping costs manageable, adjust uncompetitive laws, and reduce barriers and other cost burdens undermining growth. Because this bill would impede Minnesota's business competitiveness, we respectfully encourage a no vote on Senate File 2373. Thank you.
Thank you so much for your testimony. Up next, we have Mr. Dalton Danielson, and on deck, we have Mr. John Beshe. Welcome to the committee. If you could introduce yourself for the record and please proceed with your testimony.
Thank you, Mr. Chair. Committee, my name is Dalton Danielson, Fiscal Policy Director with the Minnesota Business Partnership. MBP represents more than 100 of Minnesota's largest employers statewide in a variety of industries. While we truly appreciate Chair McEwen, the committee, and all the staff's work on Senate File 2373, we do have concerns with where the bill sits today, particularly in the suitable seating mandate and the automated decision system and electronic monitoring provisions, which together move Minnesota toward a one-size-fits-all regulatory approach that does not align with how modern workplaces actually operate. First, on suitable seating, our members already comply with workplace accommodation requirements under OSHA, disability laws, pregnancy protections, and collective bargaining agreements. Codifying a broad, ambiguous, enforceable seating standard backed by penalties and compliance orders risks substituting statutory mandates for professional judgment. Furthermore, when definitions are left to interpretation, it creates tension between employers and employees who may disagree on whether a worksite can reasonably accommodate seating in a safe, compliant manner. Fact of the matter is, workplaces vary dramatically across industries, job functions, and safety contexts. Decisions about when sitting is appropriate are best made at the job level, not hardwired into statute. Second, the AI and electronic monitoring provisions are extremely expansive. While guarding against misuse is important, this bill regulates not just outcomes, but the means employers use to manage operations, raising uncertainty, compliance risk, and potential litigation exposure, even when tools are used responsibly and lawfully today. I believe there is a more in-depth letter, which the Chamber referred to in your packets. I encourage committee members to take a close look at this as you all decide on how to move forward. Finally, we urge the committee to consider the broad impact of these provisions and the tenuous position they will put both businesses and employees in. Businesses are still digging out of the slough of employer mandates from the past few years. Adding more one-size-fits-all mandates is not what they need right now. Thank you for the opportunity to testify. We urge you to oppose Senate File 2373 as it stands. Thank you.
Thank you so much for your testimony. Up next, we have John Beshe, and on deck, we have Commissioner Nicole Blissenbach. Please introduce yourself for the record and proceed with your testimony.
Thank you, Chair Hauschild, Chair McEwen, members of the committee. My name is John Beshe. I'm the State Director for the National Federation of Independent Business in Minnesota. NFIB represents about 10,000 small and independently owned businesses across the state, and our members span every industry and serve their local communities. Thank you for the opportunity to share our opposition to Senate File 2373 as amended by the Delete Everything Amendment. In particular, we are opposed to the language in Article 2, Sections 2 and 9, which creates a suitable seating requirement for all employers. As we've testified previously, we are concerned with the highly subjective concepts that are included in this language, which we believe will result in compliance uncertainty for small businesses with the potential for civil penalties. Small businesses are already grappling with a growing list of workplace regulations, and we do not believe that the legislature needs to insert itself into every workplace situation. As such, we do not believe that it is necessary to create an all-inclusive state law to address this matter. We also have concerns with the language in Article 2, Section 4, which modifies the required information that employers must disclose in job postings. Our primary concern is that this will set a precedent in which any perceived information gap between employers and applicants will justify a new disclosure requirement, transforming a practical tool for recruitment into a dense legal document. The underlying statute already requires employers to disclose the starting range and a general description of all benefits in the job posting, and we think that this general description suffices for the purposes of the job posting. Applicants for a job are already free to inquire about specific details regarding health benefits, retirement plans, or other benefit packages during the interview process. By requiring additional information related to compliance with a specific statutory reference, small employers will either need to perform additional technical analysis themselves or consult with an attorney or their insurer. This adds additional steps and potentially more cost to what should be a straightforward job posting process. In closing, we are ultimately opposed to the new or expanded regulations on small businesses in this bill, and we encourage lawmakers to explore policies that improve our state's competitiveness and bolster economic growth. Thank you again for the opportunity to provide comments. We respectfully ask the committee to oppose Senate File 2373 as amended by the Delete Everything Amendment. Thank you.
Thank you for your testimony. Up next, we have Commissioner Nicole Blissenbach. Please introduce yourself for the record and proceed with your testimony.
Good afternoon, Chair, members of the committee. My name is Nicole Blissenbach, and I serve as the Commissioner of the Minnesota Department of Labor and Industry. I'm here today to testify in support of the inclusion of the Governor's budget and policy provisions for DLI in Senate File 2373, as well as the inclusion of funding for an FTE to perform work related to the Safe Workplaces for Meat and Poultry Processing Workers Act. Specifically, I would like to highlight DLI's support for the construction codes and licensing provisions in sections 10 through 18 of the bill as amended, which together form the entirety of DLI's policy and budget priorities this year. I won't go into detail about these proposals since you heard testimony from me last week on those. In addition to the portions of the bill that DLI supports, there are sections that impact DLI, but we have not taken a formal position on. Because these provisions include obligations for the department, I recommend and ask that funding be provided at the full amount outlined in the fiscal notes, if they are included. These include the provisions in sections 5 through 8 of the bill related to regulating the use of AI in the workplace, and sections 1, 3, and 9 of the bill related to requiring suitable seating for employees. Thank you for the opportunity to testify on Senate File 2373.
Thank you, Commissioner. And with that, we are through all of our testifiers, and so we will open it up for discussion. Chair McEwen, did you have anything to add for member discussion?
No, thank you, Mr. Chair.
Okay. Senator Rarick.
Thank you, Mr. Chair. I would like to offer the A25 amendment.
Senator Rarick introduces the A25 amendment. Is that in our packets? Okay, it's being passed around.
You want me to speak to it?
Yes, you can. Yeah, go ahead and start, and as it's coming around, we'll.
Okay. Thank you, Mr. Chair. The A25 amendment is in regards to an issue of the bill that we heard earlier that Senator Kunish is the chief author of. In regards to the construction of storm shelters in the building code for schools in southern Minnesota. And, you know, I think hearkening back to that discussion, you know, the increased costs that this puts on, and the one group especially that is advocating for this, as someone who works in the construction industry, it always kind of troubles me as you think, what are their true motivations behind it? When you look at the percentage of that they add on to the costs of the buildings as they design it, there is a monetary interest on their side to continue to have these because it increased the cost of the project. And we heard from so many school districts across the state, they do not take safety of the people in their buildings lightly. And they believe they can offer that safety to people without this being in their building code. And so being it was not included in the bill, this amendment would bring that provision in to remove that requirement from the building code that they need to design in that storm shelter. So thank you, Mr. Chair.
Thank you, Senator Rarick. Discussion on the amendment? Senator McEwen.
Thank you, Mr. Chair. Thank you, Senator Rarick, for bringing forward this amendment so we can discuss it. I really welcome that. And I've been having several discussions with Senator Kunish about this bill and about the testimony that we heard, about all of the rationale behind why these districts are bringing this issue to us, and also talking with our members about concerns. Of course, we trust and know that these school officials are very protective of their students and staff safety. But this is always a tough question when, as lawmakers, we're being asked to remove a regulatory provision that is designed to ensure safety for people. So members, I really welcome more discussion on this. I know that I will continue and pledge to work as the bill proceeds forward to finance and hopefully on the floor. We're going to be working toward a compromise on this in some way. I know Senator Kunish is interested in that. I am interested in that as well. But I welcome any ideas or input from anybody on this committee, and I commit to you that we are working toward compromise. So at this point, I wouldn't like to add the language as is. I'm just not comfortable with just deleting this requirement. I think there's a middle ground somewhere. So I'm asking us to keep working toward that, and I welcome any discussion or ideas that people have going forward. Thank you.
Okay, Senator Kubek.
Well, thanks, Senator Rarick, for putting me in a spot of trying to have to really balance these two things off, because I appreciate what you and Senator Kunish are trying to do in terms of making it, our school districts are strapped for money, and I get that. But the meteorologist side of me goes, this doesn't seem like a great idea, because I've worked for years about storm shelters, and we just last week we had tornadoes in southern Minnesota, and they are becoming more frequent when school is still in session. And I was thinking, and I missed the discussion on this, but I was trying to remember the St. Peter tornado, which was a huge outbreak. It happened on a Saturday, thankfully, but that also I think it ripped up and destroyed a school. And so I think about those things. It is in my mind. This is a really hard conflict because I get the likelihood, of it happening. I know it's small, but it's still there, and I struggle with this. So thanks for making me struggle more.
Senator Rarick? Is there anybody else that'd like to speak to the amendment? Okay, seeing none, Senator Rarick.
Thank you, and just so Senator Kupek knows, this is all about making him uncomfortable here. No, I appreciate that, and I think part of in that same discussion, we think back to last week when those storms were rolling through, and if anybody had their television on, there were warnings all day long. And so I think that's part of I hope what we consider in this is that, we have other things in place. It doesn't necessarily have to be a one thing where you say we have the structure here at our school. We are monitoring. We have so much better ways of predicting weather, where it's going to be, where the hazards potentially could be, that if that situation is arising, which also tends to typically be in the afternoon after schools are out. Many schools have said they'll let school out early, let everybody get home safely before that kind of weather would hit. So again, I know Senator Kunish has been working with you, Chair, on this, and so I want to continue the discussions. But with that, I will withdraw the amendment.
Thank you.
Senator Rarick withdraws the A24 amendment. Senator McEwen?
Thank you, Mr. Chair. I have the make sure I get this right, the A19 amendment.
Okay. Chair McEwen introduced A19, is that what you said?
Correct, the A19
amendment.
And I believe this was passed out.
I think this was passed out, members, at the beginning of the committee hearing. So it should be in front of you already. So, Senator McEwen, do you want to describe the amendment?
Yes, thank you, Mr. Chair. Members, this is an amendment that Senator McEwen would like us to introduce to the bill, and in part in reaction to some of the discussion that we had at our last hearing, and where it was brought up, which I think is a very reasonable concern, which is that how, considering these products these AI products that businesses are going to be potentially looking at purchasing, how are they going to know? How are they going to know and be absolved of liability if they are they going to be given adequate notice if any of these products are against our laws that we are enacting to protect Minnesotans? So this is a vendor disclosure, and it's pretty. People can read. The language is very simple, just a couple of lines here, but that it requires that the vendor has to disclose how that data is used, or how that works. So this is a sort of an offer to the bill, and I would ask you for your support of it, and also we'll continue the discussion on this portion of the bill as we move forward. But that's the background.
Thank you, Chair McEwen. Senator Rarick.
Thank you, Madam Chair, and appreciate this consideration. The one question I have, what I'm not seeing in this amendment is, would this relieve an employer from the liabilities they face under the law if something was not disclosed to them by the vendor when they purchased it?
Senator McEwen.
Thank you for that question, Senator Rarick. I may see that might be a question that the courts would have to interpret with this, and maybe there is something that we could do to sort of fine tune this as we go forward. But if there's anything that our council could offer, I would welcome that too.
Senator Rarick.
Thank you, Mr. Chair. Happy to continue working with folks. I think that would be an important part to include in this. Because I'm not one who wants to put in a whole bunch of things to say, like with the vendor, big penalties if they don't do it. But at the same time, these small employers, especially, if something's not disclosed to them, I don't want to see them being held liable, and they do have large penalties in this bill. So thank you.
Understood. Thank you.
Other discussion on the A19? All right. Seeing none, Senator Pappas.
Thank you, Madam Chair and Senator McEwen. I see there's a open appropriation. Oh, that's for a different, wait, I'm not looking at the A19. Never mind.
All right. Seeing no further discussion, those in favor of the A19 say aye. Aye. Opposed, nay. The amendment is adopted. Discussion. Senator, go ahead. Senator Dornick.
Thank you, Mr. Chair. I'd like to offer the A22 amendment.
Senator Dornick introduced the A22. While that's getting...
22.
While that's being passed out, you can go ahead and describe the amendment.
Thank you, Mr. Chair. So this bill, or this amendment, just changes the amount, the civil penalty. With this bill, when it came through committee, it was at $1,000, and the bill did change quite a bit, and we're still trying to digest some of the other stuff. But for this, I just want to get at least down to $1,000. I don't understand why it was raised to $2,500 as it came out in the delete all. So it's on page 8. And it's line 8.27. So simply delete 2,500 and put 1,000.
Okay. Senator McEwen, did you have anything you'd?
Yeah, I just need a moment.
No problem.
Thank you. Mr. Chair, members, and Senator Dornick, thank you for double checking on this. I'm happy to go back and look back and just see what the dollar amounts where we were at with different things. I am inclined to just out of good faith take this as a friendly amendment and just say, I'm fine to just adopt this and as this is. This part of the bill, there's still work happening with Senator McQuaid, and I'm happy to accept this as a friendly amendment as change.
Okay. Senator Pappas?
Thank you, Madam Chair, Mr. Chair. I just was wondering about when it says like each use, and I should have asked Senator McQuaid this, each use of an automated decision system or electronic monitoring tool, just to clarify, does that mean every time you click on something, would that generate the fine? So I think it's a good idea to lower it a little bit because there is some lack of clarity there about exactly what each use means.
Okay. Further discussion? Sounds like this is a friendly amendment. Seeing no other discussion, those in favor of the A22 say aye.
Aye.
Opposed, nay. The A22 is adopted. Discussion. Senator Rarick?
Thank you, Mr. Chair. And, you know, as I look through the bill, there are a lot of, you know, simple things in here that are good. But there are a couple things that I'm just a little worried about. I get the first one, and not that I'm believing it shouldn't be in the bill. It's just one of the things that kind of happens, right? Our provisions around the AI that are in the bill. You know, when we heard the bill, there were questions, and I know we've scaled it way back of what we've included in here, and I still haven't had time to completely digest what does that mean. You know, so I think there's still some work to be to, you know, as we dig through this to see, well, what exactly does it mean, because we haven't really had the time to vet that, and I know this isn't, we don't want to dig into that. The chief author isn't here either. But so that's something I hope we continue to look at that, and I know Chair McEwen, you did say that's a portion of this that we're continuing to work on. Okay. But the part that really kind of, that I struggle with in this bill is, you know, over these last couple years, I've heard from people, whether it's average citizens, counties, schools, you know, things that we're doing that's really impacting their budgets. They're having to do more with less or make cutbacks. And in here, we are seeing an increase to a state agency once again by almost 5.5 FTEs. And I just don't understand how we can continue to grow state agencies when around the state we're hearing that others are needing to do cuts. And especially on the one provision where, I mean, it's one workplace that has really come in dealing with the seating, raising those concerns, and then we're doing this, as was mentioned by a testifier, a one-size-fits-all for around the state, and then, you know, the department needing to increase the number of employees to monitor and enforce that. That's something that I really struggle with. So, you know, adding almost 5.5 new FTEs at this time is something that I cannot support. But again, there are a number of provisions in this bill that are common sense and we should just be doing so. But thank you.
Further discussion. Senator Marty.
Thank you, Mr. Chair. And Senator McEwen, I did not oppose that last amendment on the reducing violation, but when Senator Pappas said, well, repeat things like this could stack up very quickly, I understand that. I also think, however, that some of the things like in 9923, take adverse action against a worker for exercising workers' rights or monitor workers outside of regularly scheduled work hours, not performing work-related tasks, or threaten the health, safety, or welfare or legal rights of workers or the general public. I mean, to me, those are very serious offenses and so on. I'm not saying we should change it here, and frankly, a lot of those I hope are covered by other laws, but just this might deserve more discussion next year or something.
Senator Dornick.
Thank you, Mr. Chair, and thank you, Senator McEwen, for the bill. I appreciate some of the things in here too, with the minor league baseball adjustment that they wanted. Thank you for putting that in there, and the DLI fixes there. Appreciate that. I guess the issues we have, I'll be kind of brief, but just the problem with, again, not working with stakeholders, and as I hear the business community come up, and again, being very frustrated with mandates, and it appears that not a lot of conversation is being made. But so definitely we need to continue, I say it every year, labor and industry, we need to work together, we need a partnership, because they rely on each other, and government needs to be the partnership and the peacemaker. And so encourage that, because both the seating law, which is a struggle for me too, I don't support that in the bill. Collective bargaining, I was a union member and I appreciated that, what they did for us. And so it seems for us as a government to press ourselves to make a bill, a policy for all businesses is an overreach. And then moving to the AI, I appreciate Senator McQuaid bringing up the conversation, because it is a big deal. We need to work on that. And it just seems like rushed, and there's still some things that need to be worked on as the stakeholders are trying to navigate through and help us so we don't over-regulate, and being careful to be thoughtful and careful as we make some of these changes in bills and offer ideas. So with that, I can't support the bill. I am a no vote, but I appreciate working with you, and maybe we can get through some of this on the floor or maybe before. So thank you.
Any further discussion? Okay. Chair McEwen, do you have any final thoughts?
Thank you, Mr. Chair, and thank you, members. I appreciate the conversation and the feedback. In regard to, I would just make a couple of quick points. In regard to the AAI portion of the bill, as was noted, we will continue to work on this, and we know, based on the testimony that we've heard and the work we've done in this committee over this session, this is a huge issue that we are just starting to get our minds around and our policy in gear here. So I think we understand that, and what we're attempting to do this year is to get a little start in there, and also including this in this bill this year is really important in my mind, just because of the testimony that we heard in regard to how generative AI in particular stands to affect thousands and thousands of Minnesotans, perhaps in negative ways in terms of their employment. So it really, really is important for us to really start to make some moves on this. And so what we're trying to do here is just to get a baseline going, and we'll continue to work on that language together collaboratively as we do. In regard, just real quick, to the FTEs, I think that we did hear from the commissioner, who is also wanting to make sure that we have some issues that we're working on with fiscal notes in the various portions as well. And there may be some work that we're asking DLI to just absorb. But I'm really pleased to be able to have, as part of this bill, another professional who can help with the enforcement and notification and education around the worker rights coordinator for the meat packing industry. We've heard, based on the reports, that there's dozens of meat packing plants that this one worker has been going out and just spending so much time just driving around the state, hitting all of these different places and doing really important work for employers and for working people, just making sure that people know what their rights are, what the obligations are, maximizing the safety for everybody. And they need another person. So I'm really happy to do that. And I also think that the increases that we have seen within the Department of Labor and Industry over these last years, we have seen just the immense importance of doing that, and how that investment by the state of Minnesota is really paying off right now, as we see federal enforcement and even recognition of unionized labor and organized labor really fall off. And so it is just doubly, triply important, I think, here at in the state of Minnesota, that we are making the investments where we can, so that here in the state of Minnesota, people can be confident in the business community and in the labor community that people's rights are going to be acknowledged and protected here. So I feel really good about that, but I appreciate, again, the conversation and look forward to it continuing. And with that, members, I ask for your support. Thanks.
Mr. Chair, can I ask for a roll call, please?
Roll call, requested roll call granted. Senator McEwen, will you move Senate File 2373 as amended be recommended to pass and be re-referred to the Committee on Finance?
So moved, Mr. Chair.
Okay, with that, we'll take a roll call.
Chair McEwen,
Yes.
Vice Chair Hauschild,
Yes.
Ranking Member Dornick. No. Senator Kupek,
Yes.
Senator Liskey. No. Senator Marty,
Aye.
Senator Umu Verbieten,
Yes.
Senator Pappas,
Yes.
Senator Rarick,
No.
Senator Wiesenberg.
6 ayes and 4 nays. The Senate File 2370 is passed and re-referred to the Committee on Finance. Senator McEwen, I believe you have the next bill as well, Senate File 3720.
Thank you, Mr. Chair. I do, and I have an A3 amendment as well.
Senator McEwen motions the A3 amendment, which is an author's amendment. Those in favor of the A3 say aye. Aye.
Aye.
Opposed, nay. The A3 is adopted. Senator McEwen.
Thank you, Mr. Chair. This is the addition, as I noted in my opening remarks for today's committee, that reflects the recommendations from the Workers' Compensation Advisory Council, which the council passed on Monday. I don't know if we have anybody here to speak to those. Yes, we do have the commissioner here who can come and tell us about that.
Great. Thank you, Senator McEwen. And Commissioner Blitzenbach, please introduce yourself again for the record, and thanks for providing some testimony on this.
Thank you, Chair, members of the committee. My name is Nicole Blissenbach. I serve as the Commissioner of the Minnesota Department of Labor and Industry. I am here now to testify in support of Senate File 3720, the Workers' Compensation Advisory Council bill. The bill contains 14 sections related to workers' compensation in chapters 79, 175A, and 176. Everything included in this bill received unanimous support from the Workers' Compensation Advisory Council. You should also have in your materials a letter signed by myself, Doug Loon, the Minnesota Chamber of Commerce President and CEO, and Bernie Burnham, the Minnesota AFL-CIO President, expressing support for this bill. Specifically, the bill makes the following changes. Sections 1 through 6 describe changes to the Workers' Compensation Reinsurance Association's process for excess surplus distribution and deficiency assessments and other technical changes to the WCRA governing statutes under Chapter 79, specifically in its section 79.34 and through 79.38. These changes were reviewed by DLI and the Department of Commerce prior to the presentation to the Work Comp Advisory Council. Section 7 authorizes the use of active compensation judges from the Court of Administrative Hearings for Workers' Compensation Court of Appeals cases under Section 175A.05. If the Work Comp Court of Appeals does not have a quorum available to hear a case, including from retired judges as currently allowed under the law, the Work Comp Court of Appeals may, with consent from the Chief Judge of CAH, assign an active workers' compensation judge from CAH to hear the case at the Work Comp Court of Appeals. Section 8 adds psychiatric mental health nurse practitioners to the list of providers that can diagnose workers' compensation-related post-traumatic stress disorder under Minnesota Statute Section 176.011. Section 9 updates a notification requirement for employee attorney-retainer agreements under Section 176.081. This amendment is a technical correction to coincide with the 2024 legislative amendments that updated maximum fees for attorneys in this section of law. The notice requirements in Subdivision 9 were not updated to reflect that new maximum fee at the time, so this amendment resolves that conflict. Section 10 amends the dollar amount multipliers for permanent partial disability impairment ratings. The amounts for each rating band are raised to account for an estimated $11 million increase to PPD benefits as agreed upon by the council. Section 11 clarifies that a witness for an employer's examination must be an unpaid witness. Additionally, each party must defray the cost of that party's witness. Section 12 amends the time frame for an employer or insurer that has commenced payment of compensation after receipt of notice or knowledge that the employee's disability is not the result of personal injury to terminate payment of workers' compensation benefits by filing a notice of denial of liability. Specifically, the time frame is lengthened from the current 60 days to 90 days. Section 13 relates to clarifications regarding issuing decisions based on stipulated facts in Section 176.322. And finally, Section 14 repeals items from Chapter 79 that are related to the reorganization of the WCRA changes that I described. I want to thank the Work Comp Advisory Council members for their work to get to this agreement. The members engaged in hours of respectful discussions and ultimately reached an agreement with meaningful change. I also want to acknowledge Senator Utke and Chair McEwen, who serve as the legislative liaisons to the council. Thank you for the opportunity to testify in support of Senate File 3720, and I will remain for any questions if there are any.
Thank you, Commissioner. With that, we'll move to discussion. Senator Dornick.
Thank you, Mr. Chair. Thank you, Senator McEwen, for the bill. It's a pleasure to work with you, Commissioner. You do great work, and this is always the model, right, of getting things done and the bipartisan support. I mean, the unanimous. So thank you for your work on this, and the members. We appreciate them, and so I support this. Thank you.
Thanks, Senator Dornick. Any further discussion? Seeing none, Chair McEwen.
I just want to say thank you for all of the work. I echo that. It seems to be a really productive process with everybody participating, and I would also thank my co-author, Senator Utke, as well. Ask for your support.
All right. With that, I will move that Senate File 3720 as amended be recommended to pass and be re-referred to the Committee on Finance. Those in favor say aye.
Aye.
Opposed, nay. Motion proceeds. And I am going to call on Senator Kupek.
Thank you.
Thank you, Mr. Chair. I would like to move Senate File 4640 from the table and have it referred to the Committee on Elections without any recommendations, with the understanding that it's going to come back here. And I'm happy to explain to the committee what we're doing. So this Senate file got a little bit of a late start. We heard it in elections. This is a bill that deals with fraud. Some of it that we heard in HHS committee. Senator Liskey and I heard that, and together we thought we needed to kind of come up with a bill on it. And so we're trying to find a way for it to make a track. Been tight here with Senator McEwen and the Omnibus bill. So she's agreed. Elections said they will have a hearing for it and take it. And I realize as soon as we do this, I'm actually headed to rules because it's late. But the motion will be, if it's okay with the rest of the committee, to move it out to elections, and then with the understanding that it'll be back. It does mean we'll have to all meet again as a hearing. Maybe I shouldn't say that because that might mean you might vote against it, but that's the idea.
Okay, so Senator Kupek moves that Senate File 4640 be re-referred, yeah.
I'd like to call
Senator
a roll call, and I suggest a yes vote.
So roll call requested, roll call granted. Senator Kupek moves that Senate File 4640 be taken from the table and re-referred to the Committee on Elections without recommendation. Okay, any discussion? Seeing none, those in, or no, we'll do a roll call.
Chair McEwen,
Yes.
Vice Chair Hoschild,
Yes.
Ranking Member Dornick,
Yes.
Senator Kupek,
Yes.
Senator Liskey,
Yes.
Senator Marty, Senator Umu Verbatim,
Yes.
Senator Pappas,
Yes.
Senator Rarick, Senator Wiesenberg.
10 ayes, 0 nays. The motion proceeds.
Mr. Chairman.
Senator Pappas.
Thank you. Mr. Chairman, before Senator Marty leaves, I just had a question about Senate File 3720, the Workers' Compensation Advisory Council for Senator McEwen, is why that is going to finance and why it can't go directly to the floor. If there's some other reason, is it going to be bundled with something or? Well,
Mr. Chair, Senator
Yeah,
Pappas,
Senator Marty.
Maybe the staff can tell us.
I have not looked at the bill, and I don't know, but I assume somebody flagged it for financial impacts. Even if there's not a cost, they would generally go to finance.
Mr. Chair, there's.
It looks like the commissioner perhaps has some thoughts on this, so Commissioner Blissenbach.
Yes, thank you, Chair, members of the committee. My understanding is that with the increase to PPD benefits, there will be a financial impact on the Special Compensation Fund.
Thank you.
Okay. Thank you. Any other discussion before we adjourn? All right, we are adjourned.
Thank you.